2017, as Ramya ji was sharing about the International Girl Child Day. So let me take the discussion from there. And it's interesting that when the independent thought judgment was delivered by the Supreme Court, the earlier date for pronouncement of the judgment was 10th of October. And when we reached the court, Justice Lokur, who was heading the bench at that time, he shifted the date for a day and said that we will deliver it tomorrow. So we didn't understand what was the reason. Even today, we don't know, but maybe that was in his mind that the judgment, which was so pro girl children, was delivered on the 11th of October 2017, exactly on the day of the girl child. So, uh, so that's the significance for us also. It's been 5 years now, and the judgment has impacted in several ways the issues related to girl children, especially related to marriage and POXO. And I will, during the sharing, I will also bring those highlights a little. Uh, to start with, I think most of us who are either studying law or are already in practice, either as an academician or practicing lawyers and all, we do understand that the Constitution of India is very robust document. It's one of the best legal documents you can think of. In fact, I keep telling in my sharing that when I compare the Indian Constitution with a lot of international documents, say UNCRC or even CEDAW and all, I many times realize that the Indian Constitution is far more sound in terms of what it proposes to the citizens and otherwise uh, to the humans who are staying in Indian, Indian territory. So I think the Indian Constitution is very robust, and I'll start from there. When I think of the rights of the girl child, I'll start from there. And the first point I would like to highlight and mention that though we all know that Article 14 talks of equality before law and equal protection of law, it also has a provision under Article 15(3), which specifically talks about something which we call as positive discrimination, and it talks about certain classes of people that includes both women and also includes children. And if we read it together, the girl child comes out as a very special category, which needs to be provided with little extra effort from the both lawmaking authorities and any other constitutional body. And girl children thus needs to be looked at from a little more protective lens than otherwise. So that's point one, which we must somehow, somewhere keep in mind when we talk of the girl child, that they are not only special as children or as women, but if we combine, they are special square. And so we need to look at them in a very different way than any other class of citizen in the country. So that's point one I would like to bring before the students or the prospective lawyers today. And these are frames which you can always use in your practice, in your otherwise work, uh, to both read the law and also getting it implemented in a better way. So from the constitutional perspective, they are very privileged in terms of positioning, in terms of being a right holder. They are positioned very differently. The other thing which I would like, again referring back to the Constitution, is something which is not written in the Constitution is also very important. I keep telling that Part 3 of the Constitution, which primarily takes care of the fundamental rights uh, uh, of both people in general and citizen in particular, has a very unique thing. The whole Part 3 of the Constitution does not mention the word family. Also, it does not mention the word guardian or parent. And that's very important to understand that Part 3 of the Constitution, very, very, the drafters, the forefathers, uh, very, in a very conscious way, didn't mention these words as part of Part 3. Neither the family, nor guardian, nor parent, and there must be some reasons behind it. If you look at part 4, if you look at the fundamental duties, you will find that mentioned, family being mentioned, yeah? But parents being mentioned, but not in part 3. And the significance of something not being there is so huge, and now it's on the duty bearer. So the state, what we classically call as parents patai, has been in a very very clear terms mentioned as in the part 3. And the state many times, which comes in, on a regular basis, comes and brings in the aspect of family or tradition or culture, in terms of abdicating their own duties towards the girl or the children in general, which is not supposed to be. So if you look at part 3, where the child is mentioned more as an individual rather than as part of some family or some social unit, the state has a very direct responsibility. So anything happening to parents or anything happening to children, the state must come and rescue or say intervene in whatever situation the child is. Why this becomes important is also very interesting. If you look at the different data sets which get generated by the government, be it census or NCRB crime data or the NFHS, mostly related to health of individuals and also family marital relationships and all. If you look at those data, especially the NCRB data, we realize that most of the child protection issues are happening within the 4 walls. If you look at the latest NCRB data, which has started a new section which talks about the proximity between the offender and the victim, and you realize almost 90+% of the crimes which are happening against children, the perpetrator was known to the child. It was not some stranger who was abusing. It was not any stranger who barged into the house and raped and went away. It is not such like that. And this is also a kind of reinforcement of an earlier study which was happened in 2007. It was again a Government of India study, abuse in India. And again, that report also brought out very similar facts, that most of the perpetrators are people who are known to children. They are not strangers. So if you look at this aspect, and also the fact that anyone who has worked or read on the different other issues of children, be it female infanticide or issues of trafficking, child labor, prostitution, or child marriage, all these issues, you will find that somebody known to the child, many a times the parents themselves, are involved. And so if you look at the data sets, and then you look at the kind of vision the constitutional drafters, our forefathers, had, they were so clear that we cannot put children as part of any unit, but they need to be mentioned as individual rights holder, and the state as the protector and the duty bound to implement the constitutional values and constitutional provisions, must be directly responsible for the protection of girl children or children. So that's another point which we need to be very very clear in mind, that whenever we raise issues of children, especially girl child, not only as a rights holder they are put at a higher pedestal, but also as duty bearers, state is bound to intervene. We cannot keep looking at affidavits being filed by the state where they keep using family or culture or some religious custom as a camouflage for not intervening. And why I'm saying this, in the petition which we finally led to a landmark judgment, which you all know, the affidavit of the government used family as a camouflage, saying family is sacrosanct, and there are so many child marriages happening in the country, and so as a state we are not so inclined to intervene and all those things. So I think those are not what is conceived or allowed within the constitutional frame. So state must act when it comes to rights of the girl children, and it's very much part of the constitutional side. So on the constitutional part, I feel these two, three aspects are very, very important, and this gives us a basis. This provides us a basis where, voicing for the rights of the girl, voicing towards their protection, and also singling out singling out anyone who are part of this abusive frame. It may be their immediate parents, or it might be part of the extended family or community at large, or some socio cultural norms which are seemingly as strong as the written law. All these things, when it comes to voicing concerns of the girl against all these um, uh, social, or say cultural setups which are not allowing a girl to live their life with dignity or in the fullest sense, we must use these provisions within the constitution as a basic and a very basis for argument that these must not stand when it comes to the freedom or choices of the girl child. Saying that, I would like to, take it forward and pick few issues which keeps coming up when it comes to girl children, and there are two, three issues which I feel are currently in discussion, which we must discuss, and we also must think over. It's not necessary that whatever I say must be taken on the face value, but must look towards more data and try to generate discussions on those things and develop our own argument as lawyers. And whenever there is a scope, or whenever you feel that we must pursue in the court for better judgments or better law, we must even pursue those things in the court. So, two, three things which I would like to highlight today. One, the the judgment which we got in 2017. I'll just brief if somebody is not aware that till 2017, uh, after the criminal law amendment of 2013, the provision within IPC was amended, and the age of consent under Section 375, which was earlier 16, was raised to 18. Then there was an existing exception to the main provision, and that exception said that if a girl, or say if a man has sex with his wife, and the wife is above the age of 15 years, he cannot be charged for rape. So when the parliament was amending the law, post the ordinance, the while they raised the age of consent for girls in general to 18 years, they didn't change the age for the married girl. Now, when we looked at all these kind of very quick happenings post the Nirbhaya incident, we realized there was something wrong in the way the law is being read. So just to give you a kind of a quick memory, recap of what happened around that time. POXO, Protection of Children from Sexual Offences Act, came in 2012, and it got implemented in November. The moment it came, the law not only took care of variety of sexual offences which happens against a girl child, it brought two very important things. One, it made age of consent as 18, which was at that moment not even there in the Indian Penal Code. So it raised the age of consent as 18, and it included all the possible, sexual offences within its ambit in the definition, and then made certain very stringent provisions. The second thing which it brought out very importantly was that it had no exception to the crime, which the IPC even at that time was little diluted. Now, once the POXO came into being, it was very early at that time. Not many cases had come up, so people were still in that stage of understanding the relevance of law on the ground. And then this unfortunate incident of Nirbhaya happened, which we all know. And then the government came into action and an ordinance was passed based on the a committee which was formed, which we all know as Justice Verma Committee. Now, when the ordinance came, which was based on the which was based on the
Guys, please mute yourself for having a smooth session.
so when the ordinance came, interestingly, the age of consent for generally for girls was also raised to 18, keeping making it at par with POXO. And for the married girls, the exception was also raised from 15 to 16. But when the law came through the parliament, the ordinance was then replaced by a law made by parliament. What was shocking was the fact that while the age of for a married girl was 16 when the ordinance came, it was again brought down to 15, making an age gap of 3 years between a girl who is not married and a girl who is married. And that kind of triggered a thought in our internal discussion, and we thought we must challenge this. We must challenge this because it by no standards seems to be justified or rational. And when we approached the court, we raised a similar issue that there is a serious uh, kind of conflicting provisions only to create confusion. And the main point which we raised, that the fact that a girl below the 18 years is a child by all other definitions. So a girl below the age of 18 years is a child. She cannot be kept aside, or cannot a special category cannot be created just because she has been illegally married. A marriage has happened without her consent because she has no right to consent. Even the law related to marriage does not allow such things to happen. And the other problem is that the law related to marriage, which is the Prohibition of Child Marriage Act, it itself is a little not a very strong legislation. So it keeps the status of marriage hanging. While it says it's valid, but it's kind of voidable, and a girl child or even a boy child can post his or her marriage, can approach a court within 2 years of attaining majority and get it annulled. So that law itself is not very strong in terms of what it uh, you know aims to achieve, is which is the prohibition of child marriages. So we took to the court, and the court finally, after long 3-4 years of deliberations and all, finally what they gave is now a landmark judgment. And the court clarified 3-4 very critical, crucial things. One, that discriminating or creating a imaginary group of children just because they are married while they are still below the age of 18 years is both uh, unreasonable and has no rational nexus with the object of the legislation. So that is one thing which they brought out very clearly. The second thing which they said is that discriminating with certain children while they are already the rights a girl child can have if not married cannot be snatched away only for the reason that they are married now. And so again, a very important message from this is, and I will again quote back the provisions of the Constitution, that a social status of any person or a marital status of any person cannot be and should not be a basis for denial of rights. And these are larger, I think, principled arguments which we will see a lot of them coming in different ways, in different cases in the future also, where a person cannot be denied of certain rights which are constitutionally guaranteed only because of certain social status. Now, that is a very, very strong message which the court gave. And finally, the court also said that for certain things within POXO or PCMA are on a little higher pedestal than the general law. And then they said two very clear things. One, that both POXO and PCMA are special legislation. And not only they are special legislation, but they are secular legislations also. They said they are secular legislation, and so uh, you cannot uh, keep it aside looking at the general legislation like the IPC. Even POXO, they referred back to POXO saying that section 42A also mentions very clearly that they have an overriding effect. Now, the POXO, which was both special and secular, also have a provision which clearly says that it has an overriding effect. And as I said earlier, it does not provide for any exception. In fact, it also includes relationship by marriage. So if you look at section 5N, it specifically talks about if there's a relationship by marriage, then the offense becomes an aggravated form of offense. And a person can be punished for, as on today, he can be punished for almost like 20 years. And even a life imprisonment can be imposed on that person for the aggravated offense. So if you look at the judgment part, lot of important things were kind of mentioned in the judgment, which somewhere not only recognize the right of a girl child, whatever the status she may be, married or unmarried, but also imposed certain certain duties on the state, that how you have to protect them based on the legislation passed by the parliament. And POXO being one, the JJ Act being another, and it continues. Sadly, we still see a lot of high courts who have given judgments post 2017, where they have kind of created uh, some kind of space for the personal laws in the country, and especially when it comes to marriage of Muslim girls. There are judgments of Delhi High Court also and Punjab and Haryana High Court also, where they have talked specifically that because prohibition of child marriage does not specifically mentions the uh, nature of marriage which happens within the Mohammedan community, so the personal laws cannot be denied. And so there are high courts who are still giving judgments where they say the girl within a Muslim community can be married off post the puberty, which is presumed to be 15 years of age. Now, that is what is continuing. We have also challenged those kind of judgments. There is an ongoing PIL which Independent Thought has filed in the Supreme Court, where we are talking about certain aspects of implementation of the Prohibition of Child Marriage Act, and also for declaration of prohibition of child marriage as a secular legislation, which should then apply to everyone across communities and should protect all the girls, whatever maybe her social or religious or cultural background may be. And so we are talking of something like a uniform law when it comes to protecting the girl child. The other important aspect which the judgment highlighted was a provision is in the CRPC. So there's a section in the CRPC, so offences related to marriage, which is section 198, and the sub clause 6. So 198(6) speaks about that if any incidents of rape within child marriage happens, then if the complaint is not filed within 1 year of the date of incident, then all courts are barred from taking any action. So what it means is, so if a girl child is married at the age of 12 and her husband has sexual intercourse with her, then after 1 year, so after she reaches say 13 years, even if she approaches the courts of law, none of the courts in India will be allowed to take cognizance because of this provision, which, as per our understanding, is blatantly unconstitutional, very violative, very restrictive, and should not be there in the statute book. And when I say this, we are also fighting a case in the Delhi High Court where we have challenged this provision, and it's already admitted. The government of India has is supposed to file an affidavit, but recently in the last hearing, the government of India has uh, they have submitted a short note, and in the short note they have kind of agreed to our argument, saying that because POXO and JJ Act are special legislation, so in case such incidences occur, so POXO will anyways override. So in terms of government of India's reply to the court, they are in agreement that 198(6) is maybe, lack of choice of word, I'm saying it's a kind of a bad law, and anyways POXO will override, so it will have no meaning. But that case is still going on, and we are looking for a more clear and firm verdict from the High Court. So that's another aspect where you will see how the laws in some way, what was it doing? If you look at what 198(6) intends to do, what it intends to do is that if a girl is married as a child, whatever the age may be, and if the girl has lived with her husband for a year, then it will be in terms of what I can make out, that it will be not advisable to disturb the family relationship. Whatever may be the condition, whatever may be the experience of that little girl, she may be happy, unhappy, going through horrible situations, but law closes the door. As per 198(6), law says if the girl has spent 1 year with a man, it is presumed that they are happily married, and the court has no role or no business to interfere. And even if she comes with complaint, the legal process will be closed for her. Now, what are we trying to do? What we are trying to do is, from a very, very patriarchal mindset, the law closes the door on the girl. She is left on the mercy of the social system or the social structure, which we all know are so patriarchal in the ways and the manners in which it runs, and we leave that girl with no option but to stay with the perpetrator. That man may be a good man or a bad man, God knows, but the girl is devoid of options. Now, in the 21st century, in 2022, a such situation only reminds you of places like Taliban and Iran, where there are moral policing, and the girls and the women are not allowed with their own wishes and views. So 198(6), as on today, as we fight the case in the Delhi High Court, we are very clear that it should not stand, it should not remain in the statute book. It is not only about the provision, but it's about how a freedom or a choice of a girl is being restricted, and complete denial. The language used in the provision is all courts are barred. So a complete denial of her constitutional rights to approach or say recourse to judicial remedy is again a very, very serious violation. It should not be there in the statute book. Saying that, I will now like to move beyond that child marriage thing, and also inform the group and also future lawyers that if you ever intend to work on the issues of human rights, even if not fully, but as part of your legal practice, if you want to devote, say, even 1% of your annual time towards human rights work, or work on issues of child rights or women rights or any underprivileged community, we also must use different forums, and you can really work not only through filing public interest litigations, but there are also various other forums where you must advocate towards law reform, lawmaking processes. Now, couple of experiences which we'll share with you as independent thought, what we do as human rights advocacy organization. Sir already shared our role in the parliamentary standing committee. So we were very obliged, we remain obliged that parliamentary standing committee acknowledged our work which we have been doing on child rights, and they invited us for a physical hearing. So post whatever we shared in writing, they also invited us for a physical hearing, and it was a learning experience for all of us. We tend to have very different views about a lot of parliamentarians, but believe me, the kind of the questions which we were asked in that particular forum, we were confronted with almost like 30-35 legislatures. All of them were parliamentarians, and extremely well read and extremely sharp questions, and with lot of ground experience. So it was not just only a legal discussion, but because laws happen to have an impact on the society and on the ground. So there were questions what questions they asked were very grounded. They know the reality, they know their constituency, they understand what they are dealing with. And so one of the forums is the Parliamentary Standing Committee. Now, lately, I may have missed earlier, but lately I see almost every week you will find advertisements of parliamentary standing committees in paper. I remember, and if you are not able to find that on paper, you must visit the Rajya Sabha or Lok Sabha sites, and you will see invites of various parliamentary. I know there are a couple of parliamentary committees they have invited. One is on the personal laws. There's an invite for parliamentary committee where any citizen can share their views, write them letter, and in fact, if your comments or experience are also worthy, they will also call you for a physical hearing. There's another in today's paper I saw. There's another parliamentary committee on I'm missing the subject, but again they are inviting suggestions from the citizens. So these are very good forums where you as individuals or as a group of students or even law schools can take it up, and you have very good researchers in your law schools, and like I saw some society was inviting me for the Zoom meeting. So such society with from the law school. So if they say human rights society or something, those societies can together generate or develop a paper under the able guidance of your dean and other law professors, and then you all must engage with such parliamentary committee and contribute to the lawmaking process of the state. So that's another. The other thing which you can again influence is the meeting with even ministers. Now, one of the successes of the judgment is that in 2020, Haryana also amended their legislation on the state legislation on the Prohibition of Child Marriage Act, and they declared all the child marriages happening in Haryana as void ab initio. Means that state will not recognize any marriages which happened as child. It was lying for President's assent for 2 years, and last month on 28th September, Honorable President signed that law. Now it's a law. For us, it's very interesting because it's a very rare that a government gazette, the legislation, also mentions about the independent thought judgment. It clearly mentions that the passing of the law is based on the observations made by the Supreme Court in the independent thought judgment. So for us, again, it's like a feather in the cap. The other issues I would love and like everyone today to ponder upon, and during your studies and otherwise, that there are a lot of issues where the neglect or discrimination or issues related to girl children or women happen, which people seem to ignore in the larger interest of family or in the larger interest of culture or some religious norms, and we tend to ignore, or we tend to bypass those issues and not engage in those discussions. My take is that as law students, and there must be some apart from the moot court, there must be some debating society also, where debates must be generated on burning issues. Like, say, for the moment, the recent debate which is happening on the hijab controversy. Now, in Iran, there's a anti-hijab protest which is going on. Even in some women activists in Pakistan are in favor of those anti-hijab campaigns. But in India, it seems to be going the other way around. Now, these issues which relate to women. Now, another issue is the whole issue of this, state-sponsored schemes, which in a way also sponsors dowry. Now, there are a lot of state-sponsored schemes which says if don't marry your girl till the age of 18, allow her to study, then the government will give you 2 lakh rupees or 1 lakh rupees or 50,000 rupees to marrying your girl. Now, this, in a way, what the government is saying, that we know that there is an expense when you marry your daughter, and we will bear that cost. So I'm not against that bearing of that cost. But is it in principle promoting dowry? Is it in principle state-sponsored, or say state promotion of dowry as a culture? Then there are some issues which are not that prevalent in India, but something like female genital mutilation, which are prevalent in other countries. But you also find it somewhere in India also. So there are a lot of issues of girl children, which either remains to exist, and in different ways the laws or the schemes either promotes or denies. Now, these are all issues which I feel must be discussed within part of a debating society, not moot court. Moot court are purely case-based. But these issues must be discussed as part of our debating clubs, where different viewpoints must come out and legal argument must come out as part of your debating, and looked at from a different lens. Let's see how different person views the same concept from socio-economic or cultural perspective, and what are the answers within the law, or what should be the legal perspective, or what should be a legal answer to a problem which seems to be a cultural problem or a economic problem. But the answer has to be found out from a legal framework. So what I'll do is I'll stop here. If there is any question from the crowd, I will very happy to answer.
Thank you, sir, for having such a very good thought and enlightening us with so many informative ideas and all. So if anyone have any question, please kindly put it into the chat box. If anyone have any question, please kindly put it in the chat box.
I think either I was too clear or too confusing. So
it was excellent. It was excellent. Content-wise, it was too good, because you have been listening. I just have a small. It's not a question, but under the present circumstances, uh, whether the present government or the government which will come after 24th will be in a position to adopt the uniform civil code so that everyone gets the basic human rights from all communities.
See, I think, sir, if you look at the previous court judgment, the courts have kind of have been in favor of a uniform civil code. They have always directed back to the parliament saying it's their domain. That is point one. So somewhere the judiciary, the interpreter of the constitution, they are clear that there's a need and it must come into existence. So that's part one. The second part, when it comes to parliament, on many issues, there's a kind of invalid argument of consensus building. I think there's no need for consensus on everything. We are a meritorian parliament, so it's only matter of time. Third, it's my feeling, my personal feeling, that many governments in power don't feel comfortable or do not, for reasons best known to them, don't like pushing certain controversial things, and so they wait for activists like lawyers and all to come via the court. So maybe that's another wait which people are waiting for. But if you look at the larger, the way things are moving, I don't think it should be a delayed aspect. It has to come, because now the kind of issues which are emerging and the kind of protection which is required, we may not term it as uniform, but it has to be a protection for all. The Article 14 in its principled sense has to prevail. Now, two girl children of the same age, one being protected of certain infringement, the other cannot be said because she happens to be from certain community. I think that protection, and as the the level of education and the level of information is on the increase, more and more people will approach the court. I'll tell you one classic example. We have intervened in one of the cases in Delhi High Court, where a Muslim girl, she was married when she was under 18 years of age. The marriage happened within her relative. The husband happened to be one of her relatives, and then the marriage happened. The boy went back to Rajasthan. The boy emerged back after 10 years saying, "Ki now let's join me and let's go to Rajasthan." In the intervening 10 years, that girl continued her studies, did her M.Ed, B.Ed, and she is a kind of a topper in her class. She is looking for a future which is so bright and in a different way. 10 years. Now she is in a shock of state. What is happening? Her parents, her brother are physically, assaulted her. And she took a plea, okay, allow me for a couple of days to think. Within that 2 days, she ran away. She ran away, got hold of someone, and filed a case in the Delhi High Court, asking for a similar amendment which now Haryana did, that you declare child marriage as void ab initio. Now, we as an independent thought, we intervened. We have just been allowed as an intervener in that case on this particular issue of void ab initio. Now, this is what I'm saying. As the level of education and information will increase, people will approach, and people will not agree to a status or a situation where they are deprived of rights which are constitutionally guaranteed. Why will I agree to something less if I've already been guaranteed more? So such situations are going to happen, and for me, if you ask me, it's a matter of time. It is going to happen now.
Any other question? Yeah. From anybody?
Seems there is no any question, sir. Thank you so much. Your words are really very, very motivational for us. We would like to take it further, and we'll consider this issue and we'll work as a law student on this issue, and will develop our society, and it will make it safer for our girl child as well. Now, if now I would like to call upon Aditya of third semester BLLB honors to deliver the vote of thanks.
Now, before that, I'll just like to give that any such group or society within law school who wishes to engage with the parliamentary standing committee or thinks of writing certain papers and submit. So any such attempts being made, and if you would like to engage me in an advisory role, I will be more than happy to assist. Thank you.
Thank you. We will be in touch with you. Because
Thank
I
you,
was
sir.
told
Thank you.
about this. We will get back to you. Sure, sure.
Thank you, sir. Thank you.
A very good evening to everyone present here. I, Aditya, on behalf of CMI University School of Legal Studies, Bangalore, feel privileged to deliver the vote of thanks. First of all, I would like to thank our guest speaker of today, Mr. Vikram Srivastava, advocate, founder, Independent Thoughts, for accepting our invite and for enlightening us with the knowledge and inspirational thoughts. Thank you very much, sir. Your ideas and experiences that you have shared are really helpful. Now, I would like to extend my gratitude to our Dean, Professor Dr. T.R. Subramania, sir, for always being a great pillar of support. Thank you, sir. Next, I would like to thank our beloved director, Dr. Vijay Praneshwaran, sir, for guiding us towards pushing our limits and doing the best. Thank you, sir. I thank all faculty members for helping us successfully conduct the event. Thank you all. Last but not the least, we thank all my friends who patiently listened till the end of the session. I thank each and every one of you. Thank you and have a wonderful day ahead.
Thank you very much.
Thank you, Aditya. We have now reached to the end of the session. Moreover, I would like to thank all the participants for joining the session. Have a good day.